Welcome to Rebel Chaser. My name is Gail, and I have a whole bunch of clips for you. I'm not even going to introduce them. Let's just watch.
All right, raise your right hand for me, Mr. Miller. Do you solemnly swear or affirm any testimony you give in this matter will be true? You can put your hand down. Mr. Miller, you're before the court on 2024 CR 01366 for count 1, driving on a suspended or revoked license. Count 2, no license. Count 3, knowingly drive something. I'll see the rest of it once I get the recitation. Count 4, no tag expired or invalid tag. Count 5, given a false name, address, or date of birth. Count 6, false address, name, address, or date of birth. What does your client plead to the offenses before the court, Ms. Hahn?
Your Honor, he would like to enter a plea of nolo to count 1, driving on a suspended license. I believe the state is going to null pros counts 2 and 3. You'd like to enter a plea of nolo to driving on expired tag and nolo to giving a false name and date of birth.
Count 6 will be null pros?
Yes, Your Honor, that's correct.
All right, by entering a plea of nolo to counts 1, 4, and 5, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, sir?
Yes, ma'am.
All right, factual basis recommendation, please.
Yes, Your Honor. The factual basis in this case is that on January 8th, 2024, Deputy Bailey conducted a traffic stop on Church Street and Mimosa Street here in Clayton County on a gray Chevy Malibu for not having valid insurance after running the tag. The officer made contact with the driver, who was identified as Mr. Anthony Miller, the defendant before you, who stated he didn't have his license on him and didn't know where it was. He was instructed to write down his name and date of birth so you could identify him, and the defendant wrote down the name Terrell Miller with a date of birth of October 2nd, 1993. The name and information was run through GCIC and came back with a photograph on a driver's license that did not match the driver. The officer then asked the defendant to step out of the car to detain him, and he asked for his correct date of birth and name, and that's when he provided him with Anthony Miller with a date of birth of 12/9/1985. That information did match after being run through GCIC. He also saw that the defendant's license was suspended, and the car did not have, a valid tag. The recommendation on count 1 is 12 months, 43 days to serve with credit for time in custody. The balance probated on $1,000 fine. Count 2 will be dismissed. Count 3 will be dismissed. Count 4 is $100 fine. Count 5 is 12 months, 43 days to serve, the balance suspended. No new violations of the law to run concurrent with count 1. Count 6 to be dismissed.
All right, Mr. Miller,
Yeah.
Yes, ma'am.
which relative did you throw under the bus, sir?
My brother.
Ooh, so you hate him that much?
No, I was on the phone with him, and I just made a bad conscious decision. He was like, just use my name, and I went and I did it.
I mean, because I'm just saying, imagine your brother is driving along, minding his own business. He has a minor traffic thing. He gets out, he's in his car. The police says, sir, you ran a stop sign. Let me have your license. And then they find out he got warrants for stuff that you put his name down for. And he's saying, oh, no, I didn't do that. And so he gets into an argument with the police. Who do you think wins that?
The police,
Who do you think loses?
my brother and I.
And you know your brother, because you would be on the courthouse steps talking about, well, police brutality and all of that. your brother would be justified in thinking that he's right. He doesn't have a charge. The police would be justified in thinking that they're right. He does have a charge because you gave his name, address, and birthday and all of that. And you sitting somewhere and something happened to your brother, you be like, well, you know, them bad police. No, bad brother.
Yes, ma'am.
What kind of punk move is it when you get a charge, but you're gonna pass it off on somebody else?
No, I was
Gonna man up and take the charge.
I-
You
I-
driving dirty. You knew you was driving dirty. You ain't have a license. You didn't have a tag. You just straight driving dirty.
Yes,
You
ma'am.
was already driving dirty and you was caught.
Yes, ma'am.
Take the punishment.
Yes, ma'am.
Don't throw somebody else under the bus.
You're right.
How old are you?
I just turned 38.
Your Honor.
You need to get your life. Get your life together.
Yes, ma'am.
Get your life together. Most people in this country can manage to keep a license in good stead and be able to drive to and from work and wherever else they need to go. You need to get your life together. All right, I'm going to accept your plea of no load to counts 1, 4, and 5. Counts 2, 3, and 6 will be no pros. On count 1, I'll send you to 12 months to serve. You spent 43 days for some foolishness. I'll send you to 12 months to serve, 43 days credit for time served. Balance will be probated for you to pay a fine in the amount of $1,000. That's going to be $1,420 with the surcharge. See that right there? You could have put all this money up front and got your license straight and done what you needed to do, and not get them charges. That's what you could have done.
Yes, ma'am.
But you just decided to drive dirty, thinking that if I get stopped, I'm gonna just throw my brother under the bus. Count 4, $100 fine. That'll be $151.50 with the surcharges. That'll run concurrent with count 1, so you can pay that during the balance of your probation. And then count 5, 12 months to serve, 43 days credit for time served. Balance will be suspended. That'll run concurrent with count 1. Mr. Miller, get your life. You're too old to be running around driving dirty and then throwing somebody else under the bus.
Yes, ma'am.
All right, you can go back to the sheriff's office.
Your Honor, before you leave, I just wanted to let him know if he wants to get his license fixed. He does have a few FTAs out of Henry County, Grantville Municipal, and Forest Park Municipal Court, as well as a super speeder. If he wanted in a current suspension for driving with a suspended license, but once those are cleared up, he should be able to get his license back.
So you just get court dates and you just be like, no, I ain't feeling it today.
Your Honor, I missed, I think. we-
Everywhere. He got them out of everywhere.
Okay.
Henry County, where else, Ms. Williams?
Henry County, Grantville Municipal Court, Forest Park Municipal Court, and then the super speeder came out of Coweta,
Couldn't go to court 'cause
as well as the suspended license charge.
Forest Park.
You got 4 FTAs, 4.
I couldn't go to court because when I went there, it was by the Zoom, and I didn't know the Zoom, so I tried to reschedule it, and they wouldn't let me reschedule it.
All 4 of them?
Well, the one.
That's it, Mr. Miller. I don't have time for all of this. Mr. Miller, get your life together.
Is Mr. Perales, is he present? Okay, Mr. Perales, come up to the bench, please. I want you to stand right here because I'm going to show you something. This is a notice that was sent to your attorney 5 days ago.
Yes, ma'am.
You're ordered to physically appear in County Court 13, dressed for trial. You're not dressed for trial. You're wearing blue jeans, no later than 8 o'clock. You see that?
Yes, ma'am.
Where were you?
I had my car impounded, so I had to take the bus.
Everyone else here makes it on time. Everyone else
I
does.
understand.
We are here for you.
Yes, ma'am.
You not showing up at 8 o'clock? Those VIA buses start running at 5 in the morning. I know that because I've taken those buses.
Yes.
Is a disrespect to the court and the people of Bexar County.
Yes, ma'am.
Tell me why I shouldn't hold you in contempt and fine you or send you to jail for that disrespect to the court and the people of Bexar County. Tell me why I shouldn't do it
We're not by the rules.
and not dressing for trial. Tell me why I shouldn't do it. Give me a reason.
This is all I have to wear.
What about your lateness? Because this thing about the bus, I'm not gonna accept.
It's the honest truth.
It may be the honest truth. It's also the honest truth that everyone in this courtroom was ready to go at 7:45, 8 o'clock for this docket. That's the truth too.
Yes, sir.
Let the record reflect that the defendant is present now, not dressed for court. We're gonna go forward and he takes on the burden of any discrimination that the jury may have against him for dressing the way he's dressing today. Tomorrow, when we do the evidentiary trial, Mr. Perales, go get yourself a $5 pair of khaki trousers from Goodwill if you have to.
No.
Do not appear tomorrow in blue jeans. Do you understand me?
Yes, ma'am.
Take a seat at the table. You're going to trial on that one case. Off the record, Olga.
Next, we have Tatanisha Hobson. Ms. Hobson, you have a third-degree felony evading arrest. It looks like that's out of Travis County, but we don't have any information this morning because it's out of JP 5. And that bond has been set at $7,500. Do you have any questions, madam, regarding your charge or bond amount?
Yeah, it's a bogus charge, but did I qualify for PR bond?
Let's look. Looks like it is. Pretrial services said. No, because you're on probation. Are you on probation?
Yes, ma'am.
Yeah, you know, you can't qualify for personal bond with their office if you're already on a probation or out on a bond. So,
I didn't know that.
Yeah.
This is like a bogus charge. I already took care of this charge. Well, I got a no driver's license and they just popped this charge on me. So yeah, I've already been to court for the same day that this happened. I went to court. I tried to kill myself. So yeah, and I ran into a couple of cars on the highway and then I just left. My husband was at the scene and everything. And then they say I evaded arrest. How? When I went and I already took care of the ticket y'all gave me. How was that evaded arrest?
yeah, no, and unfortunately, I wish I could tell you, but I don't. When
They wasn't even going to arrest me. They gave me a ticket. How was that evading arrest?
well, again, I'm not sure because it's coming from JP 5 and it's this time of the morning. They don't have a PC attached, but we'll try to figure out what
They just want me to get in trouble, I guess, because my husband was at the scene and everything. They called everybody. They
what's
know
the office date? When did this happen?
December the 30th, because I tried to kill myself. I ran into multiple cars. I'm paying more on my car insurance for this. Now this charge right here, they just came up with it,
Well,
ma'am.
let me get to the bottom of it for you. When was the office date? I'm sorry. What date?
December the 30th.
12:30. And you were given a ticket for what?
No driver's license. They was not going to arrest me. I thought they was done talking to me, and so I left the scene. I live less than 1 mile away from where I got that ticket from, and I went straight home. Didn't nobody come there or nothing. They didn't even tell me nothing about this charge. I've been down to Maine Police Station and paid on my ticket. This is the second month. Well, this actually the third month I got to pay on this ticket, but no driver's license. This charge right here, they just put on me.
Okay, well let me find out what I can find out on it, but yeah, and we'll see.
And they knew I was on probation because I told them all this, and it's like they trying to give
Let's
me
see if we can get you qualified. Where is your probation? What county?
It's in Travis County.
It's in Travis? I don't see that. What case are you on probation for in Travis?
From Waco. I'm originally from Waco.
What case?
Well, I'm not,
I'm sorry, ma'am. I'm just trying to get to the bottom of it. What case are you on probation for in Travis?
it's not Travis, it's in Waco.
Oh, is this the POCS from Hewitt?
Yes,
Okay, so your probation was transferred to Travis, you're supervised here?
yes, ma'am.
Okay, all right. Sorry, I'm just work with me for a second and answer these questions so we can see what we can do for you. Supervised by Travis out of Hewitt. When did you get off probation, madam?
I just started. Matter of fact, it was December last year. I lost a kid in March. I lost a kid in November. I got on probation for 5 years after that. And you think you want to live after all that stuff? So yeah, I tried to kill myself.
Okay, all right. Let's
But
see if
then-
we can get to the bottom of it. I'm gonna appoint you an attorney and we'll go from there. Okay? So court appointed counsel can get you out for free on bond, all right? But we've got to get a PC affidavit together for you. All right?
Okay, I don't know
All
what that means, but
We-
okay.
We're gonna be working on trying to get you out of there. Okay?
Okay, thank you so much.
Okay. You're welcome. Take care of yourself. Thank you for the information. We will follow up.
Okay, thank you.
You're welcome.
Ms. Hauser, can you come on up here to the table? So you could take a seat. So Ms. Is it Solar? It appears that she's not here. I don't know whether you've had a chance to work this out with her or talk with her, or does it look like this initially involved the table, or what are your thoughts on all of this?
Well, sir, well, good morning, Your Honor, firstly.
Thank you. Good morning to you as well.
Yes, thank you. It does seem to involve a table, but I don't really quite know where to start. I'll try to be as brief as I can.
Yes, please, because chances are this will be dismissed without prejudice that she can refile given his non-appearance, but
Yes, sir.
so you're not going to need to go into too much detail.
No, I won't, sir, but I'll just start with the regarding of the table and the phone call, if I may.
Sure.
I had a Christmas party for some volunteers at the center that I volunteer for. I met Ms. Solar in October and invited her to the party to meet some of the other women of our age. It was a wonderful party. Ms. Solar brought some macaroni and cheese, and she brought a table that she took out of her shed to the party that we could have to put up against our other table. After our guests left, Your Honor, Ms. Solar and her adult daughter and I were there, and I had some lottery tickets, $30 worth of lottery tickets. Each of my guests at my own expense, each had gift box that included lottery tickets. These specific lottery tickets were actually mine that I was going to open on Christmas morning. I don't have a family. My parents just recently passed away, and I was going to open those. Ms. Solar's daughter scratched the tickets and actually wanted to keep the proceeds from those. And Ms. Solar offered that table in exchange for the tickets. And I
All right.
just said that was
So
fine.
given her lack of appearance, this case will be, I'm granting, it's basically going to be dismissed without prejudice because she's not here. And then that'll be it, and you're free to go. If you want a copy of this, you can have it.
May I, sir? I don't have a email. Is there,
No,
do I
yeah.
have it now? Or,
Yeah, we can just make a copy of it right there and give it to you. You know,
may
and when
I-
it says without prejudice, it means if she chooses to refile, she can, but for today, this case is going away.
And, Your Honor, I'm not sure, I'm not sure about the courtroom, what I may ask, but.
You can ask anything you like,
all
but I
right.
can't promise you an answer.
Alrighty. Well, Your Honor,
Make sure I check the right box.
Miss Solar has called around to the places where I have volunteered.
Mhm.
I am fearful of her adult daughter and her incarcerated son. I have suspended the volunteer work at the centers where I volunteered until after Your Honor's court's decision today. But I am fearful, Your Honor, of Miss Solar and.
Well,
these-
I mean, I'm going to stop you. because if you're asking me what can I do or what should
No,
I
no.
do, I can't, let me tell you, I can't, I can't really give you any advice on that. I can't
Alright.
do that. I can't appear to be taking one side, person's side over the other in something like this. And with regard to something I can do today, if you file a petition, if you think it's appropriate, but then that'll be reviewed by a judge, but it's up to you as to what you want to do.
I'll
So
just
I don't
go,
know, which is probably not a very satisfying answer to your question, but that's about as good as I can get today.
I'll just have to go with the wisdom of your honest court.
Well, I've not really given you any wisdom other than that her petition is denied because she didn't show up.
All righty, sir. Thank you so
Sure.
very much.
Wait a minute, you've got a
Oh.
copy of it? Come on up. You can take that and then you're free to go.
Red Exa. State your name.
Mr. Davis, you're before the court today for your first appearance. I'll appoint the Office of Public Defender to represent you. You've been charged with 1 count of trespass, failing to leave property upon order. I believe that's a 2nd-degree misdemeanor, punishment of 60 days in the county jail and a $500 fine. I've reviewed the probable cause affidavit. I'm finding there's probable cause for your arrest. Sir, where do you live?
I'm currently living in Ebro, Florida right now.
Okay, and how long have you lived in this area?
All my life.
Is there a prior record on Mr. Davis?
Yes, sir. 21 paraphernalia, disorderly resisting, criminal mischief ×2, domestic, escape, petty theft, DOP. He had a release from DOC January of this year. Prior to that, it was 17 domestic DWLSR, meth. It goes back to 90s locally.
All right, sir, based on prior record, I'm going to set a bond. I'm going to set a bond in the amount of $500. You'll be able to contact them, Franklin and Friends, in order to make your bond. Your next court date's February 28th at 8:30. Good luck.
Step to your right to the T, sir.
Which one was that? Was that Mr. Davis?
Place foster care versus Mark Allen Rush, 2374-53 DZ. And agency place foster care versus Alyssa Marie Walden, 2374-54 DZ. This would be the defendant's motions to abate child support and clear arrearages. Mr. Rush appears in the courtroom. Ms. Walden appears via the Zoom application. Would you both please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God? Yes.
Thank you. You may put your hands down. Can we hear from the front of the court first?
Certainly, Your Honor. These are Ms. Walden's motions in the 2 companion family support cases. The children at issue were placed into care on April 4th of 2023. And while acknowledge the argument in Ms. Walden's motion about there not being jurisdiction in the companion file, the support program is actually only looking at the placement of the child. And as of this morning, both D and C remain out of home.
Very well. Who wishes to speak first, either Mr. Rush or Ms. Walden?
It's her motion, she can speak first.
Okay, go ahead. Ms. Walden, go ahead.
I didn't hear it.
Good morning.
Anne had stated the last statement she made. Can you repeat the last statement she made about?
Sure, Ms. Schultz, can you repeat?
Correct. Friend of the court records show that as of this morning, both C and D remain in out of home placement.
They're out of placement?
They're in out-of-home placement.
Yes. Okay, so I had done some research and had talked to my lawyer about the child support situation. It is actually on the Michigan Legal Help.org website regarding like CPS and families and stuff. And technically, child support is not supposed to be ordered until after the dispositional hearing, which occurs after the trial and after the courts get jurisdiction of the kids. So that's why I filed this motion, because technically child support is not supposed to be ordered until then.
Ms. Schultz, do you have any comment?
I don't have that information, Your Honor. The 4D program instructions only reference placement. Jurisdiction and disposition are in a companion file. They have nothing to do with this act.
Any other comment?
It has nothing to do with the child support. Is that what she stated? Sorry.
Repeat your. Sorry.
What I had indicated is that jurisdiction and disposition are under the companion file. The actions before the court today are only related to child support. And our 4D policy manual is that we look at placement of the child.
Well, because jurisdiction hasn't been given to the courts. And I mean, I can provide Ms. Schultz with the website that I had found the information on to prove that it is, you know, a real source that child support is not supposed to be ordered until the dispositional hearing. So I'm not even understanding how it was able to be ordered in the first place without the jurisdiction being made.
Anything else?
No, I guess not.
Mr. Rush, did you have anything else?
I do agree with her. I had spoke to my attorney as well, Mr. Lockhart, about this, and he did state the same thing. I understand where Ms. Schultz is coming from as it pertains to child support. She said is based under the front of the court case, but nobody has custody of the kids, which can't grant child support. Child support would have to go under the NA file, and if the court doesn't have jurisdiction and there's no dispositional hearing, can't grant child support.
May I just clarify one thing on that, Your Honor? Sure. I didn't reference custody of the child. It is only placement, whether they're out of home or not out of home.
Right, we have here the support file, there's a companion file, an NA file, which we need not discuss, but that's part and parcel of this. This affects this is regarding placement, not custody or anything else like that. As a result, and I'm not aware of anything to the contrary, respectfully, the motion is denied. That'll be all. Thank you.
And we have cause number CR 23-28789 and 790. We also had a civil cause number associated, CV 23-46358-1. And you are Mary Wright, is that correct?
Yes, ma'am, you know who I am, and I apologize.
You are okay, and sometimes folks just need a little bit more help some days than others, so.
No, I mean from a long time ago.
Oh, okay, no, you're all right. Okay, now we have Miss Wright back from the state hospital, and I believe we gave defense counsel a heads up to maybe have a chance to visit with Miss Wright. Did you want to visit with her in a breakout session this afternoon before we get started?
No, Your Honor, I met with her yesterday. And before that, she and I were communicating while she was at Terrell State Hospital.
Okay. And do you concur with their finding that she's been restored to competence?
Yes, Your Honor.
Okay. Then.
Well, yes, ma'am, I had gotten bit by a copperhead in my yard.
Okay. And so there could be a lot of different things that happen to affect us, but what we're going to do now is find out from the state's attorney and defense counsel what your plans are, what you need at this point.
I mean, I don't even remember doing that stuff.
Ms. Wright, I'm asking you to exercise your Fifth Amendment right.
Yes, ma'am.
Thank you.
We need to hear from the attorneys on the status. I don't know where you are as far as discovery, whether it's been provided, if it was provided, if you were even able to share that with your client, Ms. Hunt. So we'll turn first to the state, Mr. Briley.
Your Honor, I believe the defense has access to discovery. I have made an offer. I don't know if Ms. Hunt has gone over that offer with her client. And then I've reached out to the victim in this case to see if they're comfortable with our offer, and I haven't been able to hear back from him yet.
Okay, and before I jump to that step, I forgot to, I did not, it may be there. I don't recall seeing, was there a proposed order finding Miss Wright competent? Yes. Let me see if that's it. No, that was the one saying before she wasn't competent. So do you have a proposed order you can submit for the court to make that finding, Mr. Briley?
I can get that submitted very quickly here in the next 10, 20 minutes. I'd have to go to a different computer and e-file that.
That's fine. That's fine. We'll just have it this afternoon. Okay. And so, Ms. Hunt, we have the state indicating they've provided you with the information. Do you need more time to go over that with your client?
Your Honor, I tried to get an appointment with my client for today. I did receive a new offer from the state. I have been discussing with my client what the possible outcomes were and what she wanted to see happen with her case. I think that we have an offer that might be in line with what she was discussing with me. However, my appointment today, there was an issue at the jail, and after waiting for approximately an hour, I was told that there was some sort of security issue. The soonest I can see her is going to be on Tuesday, and I already have an appointment for 3 p.m. on Tuesday for me to go through the plea offer with her and the paperwork if she's agreeable to it.
All right.
That's where we're at.
Would you be available Thursday morning or Friday afternoon of next week on Miss Wright's case, or is that too soon? I think that's the 29th. It is a leap year. We'd spend that extra day of the year together.
Did you say Thursday morning, Your Honor?
Yeah, we can either do Thursday morning at 9 a.m. or Friday, March 1st at 1:30.
I am available on Thursday, and I believe that if I have adequate time to discuss the offer, that it might be an offer that she's agreeable to.
All right. Well, we want you guys to have the time you need, but in light of the finding of competence and some of the other needs that Ms. Wright has had with mental health, we really want to give high priority to this case. And I appreciate the attorneys doing that and stepping up and getting that done. Thank you very much. Ms. Wright, I'm going to see you next on February 29th. So that'll be next Thursday. I'll see you on Zoom again. Okay.
Yes, ma'am, Your Honor, but none of that would have happened had I not gotten bit by a copperhead in my yard.
Yeah. I'm going to have you talk to your attorney, and you'll get a chance to talk to your attorney. She's going to be out there. She already has an appointment with you. Okay. She tried to get out there today, but they had some concerns on security not related to you. So she's going to get out there though again. Okay.
Yes, ma'am.
Thank you so much.
Are these MTRPs?
Yes, Your Honor.
I need them printed. So I guess if they're MTRPs, go ahead and print them out and have them up here for me. We're figuring it out.
And Judge, I was gonna plea him to count for 1, 3, 4, and 8. I think on one set of papers, I only wrote 1, 3, and 4. But I want plea of true on 8 as well.
Okay. Which one is it?
8's the Mr. Mayor.
Thank you. Do y'all need the cause numbers? Now that I have all this up here, I don't have space for everything. Okay, again, you're Caleb Diamond. And will your client waive the formal reading of the motion in each case?
He will, Your Honor.
Mr. Diamond, in cause number 21-36568, I have a first amended motion to revoke your unadjudicated probation. Shows that you were placed on probation May 11th of 2022 for the offense of aggravated robbery, and that was a 10-year deferred probation. Is that correct? And in cause number 36570, I also have a first amended motion to revoke your unadjudicated probation. Shows that you were placed on probation May 11th of 2022 for the offense of aggravated robbery, and that was a 10-year deferred probation. Is that also correct? See that new case.
Take Sean's tampering for throwing a firearm, which he was charged with.
I don't like it. I mean, Mr. Diamond's on probation for 2 aggravated robberies where he and 2 other,
He was actually part of about an 8-person crew, Judge. That between them, they did more than the 2 that he was charged with. He was involved in several. different
and then
ways.
he's got
Usually-
and we've got a new offense with a gun.
Yes, sir.
Yeah, y'all know my,
He has, essentially, he'll be revoked in other counties.
I'm not giving them 8 years. I'm not, that's not, absolutely not. I mean, these are ones that I've been given 20, 25 years on for these young kids that won't stop carrying guns in Jefferson County. I'm not going to take this deal. Y'all can either reevaluate it. I will give you one more chance. Y'all can talk to me before you do any paperwork. It may be that it's just going to be up to me, and I don't accept an agreement on these type of cases. Go back with the bailiff. We'll reset the case.
All right, thank you, Your Honor.
Do we have everyone present on Ramirez?
State's here, Your Honor.
Yes.
Defense is here with client, Your Honor.
Okay, Rick Benya. Okay, Olga, you ready?
Yes, Your Honor.
Let's go ahead and get on the record in case number 710687 in the matter of the state of Texas versus Tony Ramirez. And let's see here. Ms. Ramirez, have you given your attorney and this court permission to go forward with your proceeding via video conference, also known as the Zoom app? All right, please stand by, ma'am. Can I get announcements from the attorneys for and on the record, please?
Rick Pena for the state of Texas.
Sam Fugate for the defense.
Okay, and Ms. Ramirez, your attorney has filed a motion on your behalf. Stand by. It's a motion to modify bond restrictions. He filed that on the 7th of February. It was accepted by the county clerk on the 8th of February. So you're going to hear from your attorney go first. Now, at the end of last year, I issued an order in December, mid-December, reinstating your bond at $3,000. And you had no drug use, no alcohol use, no possession of firearms. You were to be placed on full house arrest. Your fees were waived. And you had a no contact order with the complaining witness. And so today he's asking that your conditions be changed, and to be more specific, that your GPS monitor be amended. State, have you had a chance to review the motion?
We have, Your Honor. I thought this motion was a little moot at this point because we submitted a SCOB and you signed one changing conditions from full house arrest to GPS tracking only.
Okay, and Mr. Fugate, you want to address that? Do you want what is it you want with the GPS monitor?
Well, Your Honor, we're asking for the removal of the GPS monitor. I would say for argument, but just a short, brief summary of it is she's been compliant with the ankle monitor now for almost 3 months. She's had no contact with this victim for almost 3 years and does not want to have contact with her. I don't think GPS monitoring is absolutely necessary at this point. And to be frank, with her searching for work, showing up with a with a VCR strapped to her ankle might hinder her ability
Well,
to find work.
Mr. Fugate, I used to practice law. Believe it or not, 5 years ago, the coloring of facts, for the sake of, it's not almost 3 months that she's had the monitor. One, it's just about over 2 months. And two, if you know, you go into my closet, you'll find 50 pairs of cowboy boots, and there's shoes and boots that can go over that monitor. It's not the size of a VCR by any measure. If anything, it's the size of a pager or a beeper that goes on her ankle. So you can spare me of that, because it doesn't bode well with this court. I like accuracy. That's what I like. I like facts. Okay. So I usually don't remove a monitor until 90 days. And I don't see a reason why we should stray from that practice in this court. She's been doing well, in my view, because she does have a monitor on. It's just like people that take medication for high blood pressure or bipolar disorder. They feel good, and all of a sudden they don't want to take their meds. Well, think about it. You feel good because you are taking your meds. And the minute you take your you stop taking your meds, you start feeling bad all over again. Is there a more compelling argument for the court to remove the monitor at this time?
Well, Your Honor, in light of the court's policy on 90 days and considering taking it off at 90 days, the defense would request a recess on this hearing, and perhaps maybe we could reset it out past that 90 days. The court's, I'm looking here, the court is accurate. She was ordered to put the ankle monitor on toward the end of December. So that would make it probably more pertinent to have the hearing later.
Yeah, I've got it on, and no, I've got it on December 14th. So let me just, so we can save some time here. Mr. Pena, as the prosecutor, if she does not have any violations by March 14th, we're looking at 2 weeks, Mr. Pena, can the state agree to send the Port of Scob removing the ankle monitor in its totality?
Assuming there are no violations, say this fine with that, Your Honor.
There you go, Mr. Fugate. I think you've accomplished what you set out to do.
I appreciate it, Judge. Thank you so much.
Okay, Ms. Ramirez, no violations. Okay, no violations. And on March the 15th, Mr. Pena is going to send me an agreed order removing the monitor, and you'll be able to go down to the monitor office and get that monitor removed, only if you have no violations between now and then. Okay. All right, and I'll put that in the order for you, Mr. Fugate.
Thank you, Judge.
All right, everyone is excused. I'm going to go type up the order, and I'll be back for the 2 o'clock matter.
Thank you.
All right, Shalice Schnitz. Hello. All right, Ms. Schnitz, is there a reason you were late for court?
Yes, ma'am. I'm sorry. I was here in the building, but I was looking on the first floor, and then I came up to the second, and then to the third, and then I got confused because it said county court. So then I was afraid I was in the wrong building. And so as I was headed to the other building, I see my attorney, Shannon, and he says, "What are you doing? It's back there on the fourth floor." And I came up here immediately and sat down. I
Okay.
am so sorry.
No, I understand, but I don't
apologize.
understand why you didn't know where the courtroom was located, because you've been here 1, 2, 3, 4, 5 times.
Yes, ma'am, I understand. I have severe anxiety, and I get very nervous on these days, and I apologize. It's part of my anxiety.
All right, you cannot be late for court again. Do you understand?
Yeah, yes, ma'am, of course.
Okay, all right. You can remove the cuffs. Yes.
Yes, sir.
Your Honor, we're also ready on our other matters.
Okay, just give me a moment.
Yes.
All right, so the warrant will be recalled. That's not going to happen again. You understand?
Yes, ma'am, absolutely. ma'am.
I can understand being late, people being late because maybe there's traffic. Or either when I come in and I see a long line, I give people some leeway, but when I came in this morning, there wasn't a long line, so there's no excuse for being late.
Yes, ma'am. I apologize.
All right, so where are we on the blood discovery and outstanding discovery? Is there any more outstanding discovery?
Your Honor, that was our motion to retest the blood. We found a lab to retest the blood.
Mhm.
The circumstances, we need to find out where the sample is. Right now, the documentation that we have, we can obviously see the result that the Quality Labs has. But we don't know if they sent the sample back to BCSO or if Quality Labs retained
All right,
it.
so y'all need to find that out today.
And then, just to give a more complete, the lab that we've found that can retest the blood would require 30 days, once they receive it.
Now, before we even get to that point, you all, before you approach me, need to find out where the sample is and if the sample is even in existence. So that's gonna be done today. All right?
We'll come back then.
Yes, I mean, after you all find out where it is.
All right, calling case number 240-559-9501. Houston, Michigan versus Leah Davis. Appearances, please.
Hearing on behalf of the people.
Good afternoon, Your Honor. Kashava Kirkland on behalf of Ms. Davis, who has been advised of her rights, wishes to stand mute with the formal reading.
Court will enter not guilty plea. On behalf of your client, argument as to bond.
Your Honor, this is a very serious matter in which I'm asking for 20,000 cash surety, tether house arrest. The allegations are that she struck and pinned the complainant in between two cars with her car. And then she came back and attempted to run him over again, but he moved out of the way. He also has received a phone call from the complainant, and she said, or he called her, I believe, and said, I told you I was a lunatic. I had a shotgun in the car with me. I'm going to your baby mama house to finish this off. And the complainant allegedly has a video of that call. They were engaged in a prior dating relationship. The complainant was taken to the hospital, and this was witnessed by a Ms. Watkins, that as far as the assault. So I believe that she is a danger to the complainant in this matter. I'm asking for a cash surety bond, tether house arrest, no contact.
What's the current condition of the complaining witness? Is he still in the hospital, or do you know?
You know what, it did not say, and in the investigator's report, and there was no witness statement as well that I saw as far as his injuries, the extent of his injuries, so I cannot report anything to the court.
Thank you. Ms. Kirkland?
Thank you, Your Honor. I understand that the seriousness of the allegations here, Your Honor. This is charged as a felonious assault, a 4-year felony. I am going to ask for a 10% bond if this court is not willing to consider a high personal bond. If this court would consider a high personal bond, I would not object to a GPS tether. As Ms. Davis is now working. She is a lifelong resident. She is currently pregnant. She's 4 months pregnant right now.
Ms. Kirkland, is she now working or not working?
She's not working. And Judge, my
Not
apologies.
working.
I think it's delayed on my end. No, she's not.
No. I think you're faster than the delay.
Okay.
But go ahead.
Thank you. She is
All
not
right.
currently on probation or parole. She does not have any pending cases, nor does she have a criminal record. Given that, Your Honor, I understand that the allegations here. I think generally she's not a danger to the community. I understand the court's concern when it comes to the complainant. So I'm not objecting to a GPS tether. She cannot afford, even a 10% bond in this case. So we are going to ask for that high personal, if not 10%.
Well, she does not have any pending cases or criminal history, so doesn't look like, at least as of today, as of now, a pattern of behavior. But then again, she's only 23 years old. She's still got a lot of years ahead of her. So I'm going to give you the benefit of doubt, Ms. Davis. In this matter, given that you have a lack of criminal history. And it sounds like it may be an isolated incident rather than a pattern of behavior. At least that's what I want to believe regarding you in this case, assuming the allegations are true. So I'm going to take a chance on you, Ms. Davis. $50,000 personal bond. While this case is pending, you're not to possess any handguns, firearms, or other dangerous weapons. No contact with the complaining witness, Mr. William Hinton. No contact means just that. No phone calls, text messages, emails, handwritten letters or notes, nor through social media. GPS tether, house arrest, and no driving while this case is pending, regardless of whether you have a valid driver's license. March 8th, probable cause.
You said I'm getting a GPS tether.
Yes.
I don't want that. I would just rather stay in jail. No, thank you.
Well, you don't have any choice in that, ma'am. GPS tether, house arrest, March 8th, probable cause, preliminary examination, March 14th.
Judge, was that the
Probable cause,
14th?
March 8th. Probable cause, March 8th. Preliminary examination, March 14th. Both in front of Judge Giles. If you want to stay in jail, ask Judge Giles to put you in jail. Have a good day.
Okay, thank you. Judge who?
Next court.
Your next judge.
Well, in the meantime, do I have to wear a GPS tether?
Yes, ma'am. Step out.
And what would happen if I just obey my GPS tether?
They're gonna come around.
Miss Davis, I am the advisor to not make.
Have a good weekend.
Next, we have Travis Mitchell. Come on forward and take the empty chair. Mr. Mitchell, you have been charged with a Class B misdemeanor failure to identify. The range of punishment on that type of offense in the state of Texas is up to 6 months in the county jail and a $2,000 fine. That bond has been set at $2,500. Do you have any questions, sir, regarding your charge or bond amount? Are you requesting that I appoint you an attorney this morning to help you with this case?
Yes, ma'am.
All right. Mr. Mitchell, Pretrial Services has also determined that you qualify for personal bond, so you will be processed for release within the next 4 to 6 hours. Do you have any questions about that process, sir?
No, ma'am, I just have one question. I'm sorry, excuse the tears, but I'm 20 years old and I've never been in trouble, man.
Okay, I think they recognize that. That's why they're gonna release you in the next 4 to 6 hours. They give you some paperwork to let you know when to come back to court. I've appointed you an attorney, so just let that attorney know that you've never been in trouble before, and he'll probably get this case dismissed for you when you meet him, okay?
About the $2,500 bond, I gotta pay that?
No, sir, you've been granted personal bond, so you'll be released for free in the next 4 to 6 hours. Do you have any questions about that process?
I don't have to pay anything?
You don't have to pay anything.
I just have to come back to court?
Correct.
Thank you so much, ma'am.
You're welcome. Take care of yourself, okay? All right.
Court does call the case, People versus Darius Harris.
Bridget Coons on behalf of Mr. Harris. State your name for the record.
Darius Harris.
Your Honor, this time and date set up for sentencing. I have reviewed the pre-sentence investigation with the client. We have no material changes, additions, or omissions. At this time, we would ask the court to adopt the recommendation.
Sir, is there anything you'd like to tell me before I do impose sentence?
Yes, sir. I just want to say to the court, prosecutor, I appreciate taking your time out. When I first came up here, I don't know if you remember, I told you I wasn't trying, I was guilty. Not a bad person or a bad guy. Everybody got a pass, but I just think a racial slur directed to me got under my skin and got the best of me. Apologize about wasting your time because that's something I could have handled better, but it just got under my skin. I truly apologize.
I think I told you I didn't think of you necessarily as a bad person.
At the moment, I work so hard, coming from my family tree, my grandfather, things of that nature. Still no excuse. Supposed to have to conduct yourself in a certain way in public. I work hard not to be called that. I work hard not to be looked upon that. I'm a very smart young man. I'm a CNC programmer and CNC operator. And when I was called that, it just kind of got under my skin. But that's not the way you handle stuff, and I understand that. I know that. Just not the way you handle.
You knew that before it happened.
And I just let it get under my skin.
Yeah. And I'll just say this to you. You know, when I took this position probably almost a quarter century ago, God, that sounds weird. But Emily was here with me. She was 5. But you just, one of the things I learned real quick, and I knew it because of how I was raised, people are going to call you all kinds of things, right? And so I just developed this saying in my mind, you can call me whatever you want as long as you call it with respect, right? I don't let those words and those things get under my skin. And the reason is because whoever is saying that to me doesn't know me. And the only way, right? And you know what I'm saying, right? You know what I'm saying?
Yes, sir.
And since you don't know me, you can't really say that about me. And the only way I let that get under my skin is if at any given moment I begin to think that about myself, and I will never, ever think that about myself.
Yes, sir.
So I'm telling you, young man, don't ever let that get under your skin, because that's not you.
Yes, sir.
Right?
Yes, sir.
You weren't raised that way. And I dare say this, because I know it. Your ancestry does not dictate that that's you.
Yes, sir.
You hear me?
Yes, sir.
And I know your people told you that too. So all I'm doing is repeating everything they told you. Right?
Yes, sir.
And I'm just sharing with you what my mama taught me. And she was the smartest woman in the world, ever, always was, and there always will be. Got it?
Yes, sir.
Because you don't need to be here. Right? No, I know. But you don't need to be here. Not for something like this. We're better people than that.
Yes, sir.
It's really simple. Sense of the court. I'm changing this a little bit. Sentence of the court. I'm going to place you on 6 months prosecutor deferred sentence. I'm going to order $555 fines and court costs. I'm waiving all of those costs except 125 of those costs. Probation oversight fees would then be reduced because of the probationary period to $180. When do you think you can get all that paid, young man?
I was trying to pay it today. My check and direct deposit first thing in the morning. I get paid.
Get it paid by this Friday, the 1st.
Yes, sir.
There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete an anger management class. You're to do that within 60 days. You're not to have any contact with Joseph Brendanetz directly or indirectly. No going to the Kroger at 3200 Carpenter Road, Ypsilanti, Michigan. No assault or threatening or intimidating behavior. You're not to possess any weapon, firearm, ammunition, or anything fashioned to be a weapon. You're to report to probation as directed by probation, including any home visits. You're to maintain employment with verification to probation. I'll set a review hearing that's to be held February 12th, 2000. Well, actually, that's going to change the date. Miss Clara.
Oh, 6 months, sorry, you're right.
It's okay. The review date will be August 14th, 2024, 9 a.m. I'll order 93 days in jail that is suspended. Out there, just act like the prince that you are, my friend.
Yes, sir.
Thank you.
Thank you guys so much for watching, and I'll see you next time.